You're tuned in to More Living with Jim Brogan, broadcast live from the Brogan Financial Studios at News Talk 98.7, where old-fashioned values, expert knowledge, and genuine understanding come together to give you the retirement straight talk you deserve. Jim's a former National Advisor of the Year recipient and a financial educator, and he's here today to talk about how you can live out the best years of your life. Jim and the Brogan Financial team have been helping retirees and pre-retirees across the Southeast for over 20 years in their pursuit of financial independence. You can reach them during the week at 865-862-6800. So sit back, relax, and get ready to learn, because More Living with Jim Brogan starts now.
Hello, East Tennessee, and welcome to More Living with Jim Brogan, where it's all about living the best years of your life your way, as you listen to News Talk 98.7 WOKI. And, you know, the United States was built on, of course, we have three branches of government. We have the executive branch, we have the legislative branch, and we have the judicial branch. And, of course, the judicial branch is responsible for interpreting the law and making sure our rights and freedoms are protected. There are certainly several key challenges that have currently faced the U.S. legal landscape. Certainly, we think first of the Supreme Court, including is there politicization of the Supreme Court. We think of challenges about ethics, accountability, the influence of special interests. What are the balance of powers between the three branches? Because I think we have ebbed and flowed different ways over the years. Today, I'm joined by Benjamin Barton. He's a University of Tennessee law professor and author of several books focused on the profession of law, law schools, and the American justice system. And, of course, we've had an eventful Supreme Court season this year, so I really want to kind of dive into things with Ben. Good morning. Welcome to More Living.
Good morning. Thanks so much for having me. I really appreciate it.
It's great to have you with us. Talk about how you got started with your law career and what brought you to the University of Tennessee.
So I clerked for a federal judge. I worked a couple of years at a big law firm, taught for 2 years at Arizona State, and then was recruited to come here to Tennessee in 2001. I've been here ever since. Once you get here, you can't leave. We love it.
That is true. But you went to University of Michigan Law School, is that
sure
right?
Did,
so,
yeah.
So are you maize and blue, or are you orange?
So listen, I interviewed at Michigan. They didn't give me the job, so that was it.
It's orange. It's big orange
for the home team. You know what I mean? Yeah,
yeah,
I've been
absolutely.
a season ticket holder for basketball, football since 2003. So I've seen some ups and downs, but it's been a pleasure.
Yeah, it has been great. When we look at let's start with the three branches of government. It seems like things kind of ebb and flow. I know 10, 15 years ago, I felt like the judicial branch had way too heavy of a hand. Now, of course, people are concerned about the executive branch. The legislative branch has ceded a lot of power to the executive branch over the last 20 or 25, 30 years.
Well, even longer than that, yeah, since the 70s.
Yeah, so what is your opinion of the balances of power and where we are? It seems to me like Congress has really ceded a lot of power to both branches. What are your thoughts on that?
Yeah, I agree with that. Here's what I'll say about it. In the Federalist Papers, they call the judicial branch the least dangerous branch, and that's what it's designed to be. It doesn't have an army, it can't tax you, and it can't spend money. Over time, though, you can see that it, in fact, can be quite dangerous because depending on how they read the statutes and work on the Constitution, they make a lot of big changes.
So talk a little bit about the expansion of the executive branch over the last, you said 50 years. I was talking about 30 years. But, every presidential administration, we get more and more executive orders.
For sure. Which
can't really last. I mean, our system wasn't really built for that, right? It was built for the legislative branch to legislate.
Yeah, I picked the 70s for it because the mid-70s after Nixon, there was a big retrenchment. They actually took a lot of power away from the executive branch. And then the executive branch has been clawing it back ever since. It's not how it's designed. It's supposed to be designed where the laws start in the legislative branch and the executive branch does what we say, which is execute those laws. What we've seen is just increasing gridlock on the legislative side and frustration on the legislative side. And so this has been a bipartisan thing. Obama, when he was having trouble with the legislative branch, issued a whole bunch of executive orders, and now we've seen a similar thing with the Trump administration.
That's a good point. there's been so much gridlock. It's just been so bad, and so I guess it's kind of been a natural evolution where we can't really get much done unless the executive does wield a little bit more authority.
Yeah, but that's not how it's supposed to be.
No, I get that.
Yeah. And actually, it reminds me a lot of the post-Civil War period, sort of the late 1890s. That was the last time where you had this flip-flop with one-term presidents. That was the last time where you had a president who was in, then out, then back in. And there was broad dissatisfaction amongst the public with the government and just generally, and that's exactly where we are now. I mean, the right track, wrong track numbers are a disaster, and people are just really fed up and frustrated with the government, and they want to see action. But paradoxically, that means that we're even more divided at the legislative branch. Everyone agrees that we need action. They just can't agree on what that action should be, so that's where we end up.
Yeah, because Congress has, all-time low ratings, but then if you ask people about their local congressman or woman, the favorability ratings are pretty good.
Oh, yeah.
For their own individual congressman.
Oh, yeah, totally. That's certainly true for Pritchett, yeah.
Yeah, absolutely. Let's talk about the Supreme Court. Certainly the legal landscape has changed a lot over the centuries. It seems like it is quite contentious right now.
Yeah.
So there is a perceived politicization. Do you think that's accurate? Is that fair? Is the court really trying to put politics aside? I mean, you hear Chief Justice Roberts saying we're not a political court. What are your thoughts?
Yeah. So first I'll note, in terms of politicization, this is not the all-time low. I mean, when FDR was his second term, he threatened to pack the court. He was so mad at the Supreme Court, he was going to add an age limit and add 3 more Supreme Court justices just so he could get a majority. Because in his first term, they struck down big chunks of the New Deal. And then in the Reconstruction period, they were so mad at Andrew Johnson that they added a Supreme Court justice. So they went from 9 to 10, and then they went from 10 to 7 so that he couldn't add any people to the Supreme Court. And then when Johnson lost and Grant came in, they moved it back to 9. That's how they rejiggered the number of people in the Supreme Court. So you can imagine that was way more politicized than what we have now.
Talk about the justices themselves, though. We think of conservative justices and liberal justices. Is that fair? Is it unfair? What are your thoughts?
Oh, yeah. So I think that that's super fair, but I also don't think that's unusual. And I also think design-wise, I mean, the court was meant – so they get lifetime tenure, so they're allowed to change their mind as they go. That being said, they're chosen by the president with the advice and consent of the Senate. The framers and everybody else understood that when a politician chooses a judge, they're going to try and choose a judge that agrees with them. That's just the nature of it. They knew that coming into it. So I don't think that the framers would be surprised to find out that there would be conservative judges or liberal judges or judges who agreed with the presidents who appointed them.
So one thing I do want to ask you, Ben, we're visiting with Ben Barton. We're talking about the U.S. landscape. He's a professor of law over at the University of Tennessee. You know what? Let's do this. Let's get to our first break.
Great.
And when we come back, I want to dive into more stuff. I have a couple of big things I want to talk about, and I don't want to be cut in the middle. So let's go ahead and get to our first break. When we come back, we'll have more with Ben Barton. This is More Living with Jim Brogan here on News Talk 98.7 WOKI.
Welcome back to News Talk 98.7's Brogan Financial Studios, where Jim Brogan is coming to you live with important news and advice to help you achieve your dream retirement. Get ready to learn and live. Here's your host, Jim Brogan.
Welcome back to More Living here on News Talk 98.7 WOKI. I'm Jim Brogan. We're visiting with Ben Barton. We're talking about the U.S. legal landscape. He's a professor of law over at the University of Tennessee. And Ben, what I wanted to get into, and I felt like we weren't going to have enough time before break, is when we say the words, when it comes to the law, and we say the words conservative and liberal. Ultimately, when I think of that, and I'm not a lawyer, but I think of how we interpret the Constitution.
Yeah.
Give us your definition. What's a conservative justice? What's a liberal justice? And how can we fundamentally have such disagreement over the Constitution?
It's a fantastic question. I love this. Thank you. And I'll note, I actually use small c conservative and small l liberal when I'm teaching to the students in a different way. So small c conservative, dictionary conservative is just, I don't like changes. I want things to be the way they are. Small L liberal is actually not the opposite of conservatives. You can have liberal conservatives. The small L liberal is, I'm a super open-minded person. I want to hear all the arguments. I just want to hear everything coming in, and then I'll decide. On the court, what it means, and this has changed over time, the current version of it is the conservatives on the court think that the Constitution should be read as it was written at the time it was written based on what the people who wrote it thought. The liberals on the court say, well, you can take that into account, but things change over time. And when you use a word like due process of law, or you use a word like equal protection of law, you don't think that those words are going to be frozen in time. You think those words will be read in context with what's happening. And so I try and present both of those sides because I think both are reasonable versions of what the Constitution does.
Let's talk about the past session of the Supreme Court. What do you think were the big cases that were eye-turning? To you, were there big surprises?
No. And part of the situation that we have in the court now is we just don't get very many surprises anymore. You can do a pretty good job of predicting what the justices are going to do.
Based on their questions or based on their ideology?
The latter. I mean, you could tell the questions frequently reflect ideology, but we haven't had a case where it was like, wow, I can't believe it for a minute.
So what do you think were some of the, maybe if you just wanted to point out the two or three most important cases that we've seen
Well,
here?
one that we know from Tennessee is U.S. versus Skermeti. That's the Supreme Court case that upheld the ban on treatments for trans youth, basically. So that was a 6-3 case. And Supreme Court said that what Tennessee had done and now what a number of other states had done in terms of trans youth was fine and constitutional.
Talk about how it's interesting as I was preparing for this show and read some of your materials about the evolution of the judges. That's really not very diverse, is it?
Yeah.
We think they have very different they have very different ideologies. Talk a little bit about some of your concerns about the lack of diversity in the court as compared to previous generations.
Absolutely, yeah. So the first thing I'll note is you don't have to stare too long at these group of people to know they're diverse in terms of race and gender. So there's more women on the court than
which is typically that's the labels we put on people. But in terms of their backgrounds,
we've rarely had a court that's as undiverse as this. So in the past, you used to get Supreme Court justices from all walks of life. So there's a former president of the United States who was a Supreme Court justice. There's a whole bunch of former senators and House of Representatives people who got to be Supreme Court justices. Some of them were just the best lawyer in America or the best lawyer the justice knew. They came from all walks of life. There's 10% of the Supreme Court justices had no formal education whatsoever, meaning they never went to college, they never went to law school. They just read the books and then came into the.
Yeah, how would somebody that didn't go to law school be appointed to the Supreme Court?
Well, the apprenticeship system was the system all the way through the 19th century. So these were hard. Andrew Jackson appointed a whole bunch of these folks who were hardworking folks, cut their teeth in the military, then went and read law, and then became fantastic lawyers. We used to have a lot more people who had been in the military. We used to have a lot more people who had ran their own business. You had people who came from a diversity of backgrounds who had done different things, and then they brought this kind of practical wisdom to the court. The current version of the court,
it's very academic.
From the time that they started at 18, you'd be hard-pressed to find people who had had a more similar background. And weirdly,
in 18.
Alito and Sotomayor are perfect examples of this. They both went to Princeton as undergrads, and they were actually within 10 years of each other. Then they both went to Yale. They both worked in fancy prosecutor jobs. They both worked at fancy law firms. They both were Court of Appeals judges and then made it onto the court. 8 of the 9 justices went to either Harvard or Yale Law School.
I guess Coney Barrett's the only one that
totally.
did it.
Yeah, yep. And 8 of the 9 justices went to an Ivy League school or Stanford undergrad. So it's a really, really, really high-level group of people. If you want to say it's the smartest group of people that have ever been Supreme Court justices, I'm not going to argue with you. The problem is they all have the same background. They all come at it in the same way. They write these really long opinions, super long opinions, opinions that are 100 pages or more to decide things. And they're like beautifully written. They're richly researched. But no ordinary American is going to dig their way through these opinions and understand what the heck is going on. And when you're making big decisions like this court is making, these are not legal decisions in some of them. Like some of these are just big political decisions. So, for example, and I'm not going to get into which side anybody agrees with, but if you're going to overturn Roe versus Wade and change how abortion is going to be treated in this country, don't put out a 200-page opinion with a whole bunch of concurrences and separate dissents and things that no one could ever drive their way through. Give us a nice, short, 10-page opinion. This is what we did. This is why we did it. Give it to us plain so that people can understand it.
It when you talk about that, when I think about it, is it fair to say it's too academic? It's academia.
It is absolutely. It's way too academic. And each one of these justices has been the smartest person they know for their whole life. And it's rough. And I'm saying that's a bipartisan thing. That's all of them. And it's totally reflected in the work that they do. They're continuously trying to prove that they're smarter than the next guy. They've got to write it more length than other people. Brown versus Board of Ed, so one of the very most famous Supreme Court cases of all time that overturns Plessy versus Ferguson. It's a 12-page opinion with a half dozen footnotes, and it just lays it out nice, plain, and straight. There's a paragraph at the end of Brown versus Board of Ed where they say, separate but equal in the area of education has never been right. We're overturning it, and they just explain it to you. Now, you didn't have to agree with it, but they told you what it was they were doing. I mean, that's a case that's still taught in 8th grade civics classes all over the country. Dobbs is the exact opposite. I mean, it's just hundreds of pages. You can't make heads or tails of the dissent versus the majority versus the concurrences. They're just not taking the time to explain their work.
Not real practical.
No. And that's exactly the point of the diversity of backgrounds. Believe me, if you the Supreme Court, there's 3 big wars where justices fought in. They fought in the Revolutionary War, the Civil War, and World War II. And if you think about it, those are the wars where every American fought, right?
Yeah.
So it makes sense. Oliver Wendell Holmes, who was a great justice, but also super practical, he'd fought for years in the Civil War. He almost died 3 different times in the Civil War. Believe me, he understood the stakes of war versus being on the court, and he understood practical wisdom. Like, he brought all of that with him to the court. Holmes said that the most important training he had for the Supreme Court was his time at the Civil War.
Wow. You know, I hadn't thought about the fact, it's the first time I've heard it, Ben, that each of these justices have always been the smartest person in the room.
Yeah. And there's that, and then there's also...
That's kind of scary, though, because
totally agree.
We want to challenge each other. We want to have diversity of opinion. We want to consider other thought and be able to be challenged.
Yes, absolutely. And there's a version of it where people would say, hey, Ben Barton, they're just appointing the best people that they can find. But to a certain extent, when you get all of these people who come at problems the same way, think about it the same way, and again, note, I'm not talking politics. These people very much disagree on politics, but what they don't disagree on is writing long opinions. They take fewer cases than they used to take. They used to take more than 100 cases. Now they take 80, 70 cases. So basically they work less, they write more. They're doing things that smart people do, but not necessarily that wise people do.
That's a great word right there. I know we were talking off air. You know, my father was general counsel at the University of Tennessee from 1975 to 1999. And he argued one case in front of the Supreme Court.
Oh, good for him. Congratulations.
Yeah. And he won 8-1. And they had lost at the University of Tennessee had lost the original case. They lost in the appellate court. And he was not the attorney. He had assigned it to one of his lawyers. And after they lost the appellate case, he's like, this is stupid. We should not lose this case. We're going to appeal it down and taking the case over. And the reason I remember this back in the 80s, and at the time, I'm pretty sure the number I heard was they take 1 out of 20 cases. But now that's 1 out of what?
Oh, yeah. It's way smaller rate to that.
Yeah. And he didn't think they'd take it, and then they did.
Yeah.
And matter of fact, Sandra Day O'Connor asked the first question.
Oh, is that right? Really?
He talked about that a little bit.
Tough.
Yeah.
Good for him. That's great.
But yeah, now they hear. So we were saying they hear fewer cases. There's a whole lot more cases being submitted.
Right, and they take longer on them. It didn't used to be that you had to wait until the middle of June for them to get the cases out. And the reason why is the case comes out and it's got a majority and a dissent and 3 concurrences, and everybody's writing separately, and everyone's got to get their own word in to show how clever they are, that they've got a different take on it.
This whole smartest person in the room thing is our advice and consent process, which is inherently political. It seems like that would contribute to that somewhat.
Yeah, I actually think that the biggest issue with it is the politicization that we were talking about earlier. So part of the thing that's funny about it is it's a self-creating cycle. It's like as the Supreme Court does more things to bother, there are long stretches of America's history where people couldn't name people on the Supreme Court. They didn't notice it. They didn't know what was going on in the Supreme Court. And that's because the Supreme Court was just lying low, doing their business, not kicking hornets' nests, not doing politically active things. And in fact, after the court packing thing, there's a long stretch where the Supreme Court kind of goes to sleep, like all the way through the 30s, 40s, and 50s. It wasn't like you heard a lot about the Supreme Court. Chief Justice Warren's confirmation hearing at the Senate, it was less than an hour. No questions. Just came in. He'd been governor of California. You seem like a qualified guy. Enjoy yourself on the Supreme Court. Can you imagine nowadays?
Well, and I know one of the things that was brought up a few years back when Justice Scalia passed away, when he was confirmed, as staunch as he was in his views, it was, 98-0?
Yeah, no, for sure. That's how we used to do it. And so now it's super political now. So as a result, the presidents are like, well, you know what we want to do is we'll just take background off. We'll get the smartest person we can find. So they went to Yale undergrad and Yale Law School, and then they clerked on the Supreme Court. Oh, and this is the other thing. 6 of these justices has clerked on the Supreme Court, including they replaced the justice that they clerked for.
Yeah.
It's just like a complete replication of the body itself. It's just very unhealthy in my mind. But anyway, they want to take background off the table because they know the confirmation process is going to be bad. So they think at least we can show that these people are the smartest people we could find. But I don't know if you've watched the confirmation hearings. I don't think that's helping very much. Like ask Justice Kavanaugh how much it helped to be a Yale grad in terms of his confirmation.
Yeah, it's gotten really ugly. So I don't want to talk about Roe versus Wade. What I do want to talk about is the overturning of longstanding cases.
Yes.
Because that's been a big discussion point. Should we be concerned about the stability of legal precedent? Has this happened throughout our history?
Yeah, so it's a hard issue, actually, and here's why, and I know I'm going to sound too law professor to say it's hard. First, everyone agrees, and I think everyone who's listening to this is going to agree, that sometimes you have to overturn old precedent. Brown versus Board of Ed is the perfect example of it. Plessy versus Ferguson was wrong. It shouldn't have been done the first time. When they got a chance to fix it, they did. No one objects to that. Like that there is a time always where you have to change it. The hard thing is drawing the line between that. My personal take on it is that elections have consequences, and the Roe versus Wade one, not that I'm saying which side is right or wrong, but the Trump and other Republicans had run on, we are going to overturn Roe versus Wade. That's what we want to do. And so Americans should not have been super surprised when that's what in fact happened.
Yeah. It seems like we kind of got a mess on our hands just with kind of where we are. Although it's interesting, I was at a conference a few years ago, and Trey Gowdy, the former congressman from South Carolina who's now on a commentator, he was the keynote speaker. And he had an interesting, he said, and I'll never forget this, he said that Washington is not a leading indicator. It is a lagging indicator. He said it is a reflection of what's going on around the country, and it's a lagging indicator.
Yeah.
And I thought that was very interesting because that, and to me that gives me hope, because if there's a really, really solid movement to change the politics of how we do things right now, Washington eventually should reflect that.
Yeah. Well, believe me, from your lips to God's ears, I don't know that I'm seeing it. But the sad thing about that is if Washington's a lagging indicator, then we've been fighting for a long time, because it's bad right now politically. Yeah. And again, I'm not saying whether I agree or disagree with what's happening. I just think the level of acidity, the arguing has gotten really, really bad.
We're going to get to our second break. When we come back, I want to get into some of the current things we're hearing a lot about, like voting rights, the justice system getting so involved in prosecuting politically. And we also want to talk about the problem with law schools in America and kind of the future of the law trade. We will have our dollars and cents segment. Is the S&P 500 truly diversified? And what does diversification actually mean? So stay with us. This is More Living with Jim Brogan here on News Talk 98.7 WOKI.
Welcome back to News Talk 98.7's Brogan Financial Studios, where Jim Brogan is coming to you live with important news and advice to help you achieve your dream retirement. Get ready to learn and live. Here's your host, Jim Brogan.
This is More Living with Jim Brogan, where it's all about living the best years of your life your way. We're with you every Saturday, 9 a.m. to 10 a.m., and again from 3 to 4 p.m. right here on News Talk 98.7 WOKI. We've been visiting with Ben Barton talking about the legal landscape. He's a professor of law over at the University of Tennessee, and we've been kind of honed in on the Supreme Court. I actually wanted to get in a few other things in terms of how our whole system is working. However, before we get back to Ben, it is time for dollars and cents.
You are getting the most out of your retirement? For all the years of your retirement? That's the primary goal of More Living with Jim Brogan and our Dollars and Cents segment, where we provide you with an important financial tip that will help positively impact the quality of your life in retirement. And now, here's Jim with this week's Dollars and Cents tip.
Is the S&P 500 a diversified stock index? It's becoming less and less. So let's fundamentally, what does diversification mean? I know, typically we think the most common answer that I get when I teach and speak is, don't put all your eggs in one basket. And the way I like to think of it is you have things that don't always, one thing zigs, another zags. So things don't just move up and down together. And diversification is an important word to understand, because when it comes to stock diversification, when we're diversified within the stock market, that means we don't have too much of any one holding or one segment or one industry grouping where that one holding or industry could drive the entire portfolio performance. However, you are going to have systemic risk when you're in the stock market. When you're diversified, one company going under, one industry having a bad turn isn't going to ruin the day for you. But if the stock market, there's an old expression, a sinking tide sinks all ships. If the market's down 35% and you're diversified in the stock market, you're going to be down a lot. But it's important to understand the S&P 500 is a weighted average index. So we think it's 500 of the largest stocks in the United States. Each stock does not have a 1/500th impact on the movement of that index. It's weighted, meaning the bigger a company is, the more it impacts the movement of that index. And there's been much discussion over the last 5 years about the Magnificent Seven, the big technology companies. And I'm looking at a chart right now, and really we could call it the Mag 2 now. I'm looking at over the last 45 years, since 1980, the weighting of the top two holdings in the S&P 500. How much of that index does it make up? And it's the highest it's been. The highest two market cap companies right now, the largest two companies in the United States are NVIDIA and Microsoft. And that makes up 14.9% of the entire S&P 500. Highest previously in 1982, IBM and AT&T made up 10.9%. And we've seen this continued escalation, especially over the last 7 or 8 years. And it is way higher now with NVIDIA and Microsoft than it's ever been. So the point of that is, when you're invested, when you look at the S&P 500, is it as diversified as you think? Because those technology stocks are really driving much of the performance of that index. So be careful if you just go out and buy an S&P 500 fund, you could be a little exposed, certainly, to technology, artificial intelligence, and all those things. That's been great the last 5 years with performance in the market. We do need to be careful we don't have too many of our eggs in the AI bucket and that you have other diversification in your portfolio.
That's our Dollars and Cents segment for this week. You can find this week's Dollars and Cents segment and others by visiting BroganFinancial.com.
And do check us out on BroganFinancial.com. We've got a wealth of resources. I do want to mention my next class that I teach, Adult Education, is at Pellissippi State Community College. It's a one-night, 2-hour class. It is income planning for retirement. So if you're retired or getting close to retirement, we're going to talk about specifically that one topic, which will include things like Social Security election, income taxation in retirement. You typically have more control of your taxes in retirement than at any other time of your life. Talk about how you structure income to not be damaged by short-term market volatility, but yet get growth over the long term to fight inflation. So if you need more information, go to PellissippiRetirementIncome.com. You can also call Pellissippi at 539-7167. Again, it is Tuesday, August the 26th at Pellissippi State, Hardin Valley. Would love to see you there. You can find all of our upcoming classes both through Pellissippi State's Community Outreach and through University of Tennessee's Adult Education. You can go to my website, BroganFinancial.com, and click on classes. Today we're visiting with Ben Barton talking about the legal landscape. And let's kind of dive into a few of the hot button issues. There's a lot about voting rights right now being talked about, many of which center around access to the ballot, legal protections. What are your thoughts? What are some of the key Supreme Court decisions that have impacted the Voting Rights Act of 1965? Walk us through a little bit about that. Protecting voter rights, but also making sure the system's not abused.
Yeah, so the Voting Rights Act is the 1965 Act. We're coming up to our 60th year anniversary for it, and it's rightly considered just a landmark civil rights act. In fact, if you chart all of the different things that happened in civil rights, including Brown versus Board of Ed and Title VII and the protections for your jobs, probably the Voting Rights Act is considered to be the number one act that changed the nature of the country, because basically it guaranteed that everybody was going to have a chance to vote, and that had not been the case before 65. The biggest Supreme Court case on that is Shelby County versus Holder. That's 2013. So before that, under the Voting Rights Act, if you lived in an area where there had been discrimination based on race, and that's basically the southern states, then you had to, any changes you made to districting, any changes you made to voting rights had to get pre-cleared through the Department of Justice. After 2013, they got rid of pre-clearance. You could still sue afterwards, but you can see how pre-clearance is a more powerful step than suing afterwards. And so people were very much up in arms about that, and you can make your own call on it. The Supreme Court and John Roberts, the Chief Justice, wrote this opinion. Supreme Court basically said that part of the Voting Rights Act was based on historical discrimination, and by 2013, it's been a long time. It's been a long time since we've had that historical discrimination, so we think this is too strong to have the Justice Department pre-clearing things. And people agreed or disagreed with that.
Well, and that's been an underlying thing going on. I mean, you look at affirmative action, you look at all the stuff going on. It's like reversing previous discriminations versus where are we now?
Yes, for sure. And there's a decent chance that the Voting Rights Act altogether may be overruled because they may say, well, it's not only just the preclearance. We don't need any of this anymore constitutionally. And you're right. The drift constitutionally, again, you can make your own call on this. Then this is the SFFA versus Harvard. That's the affirmative action case. Supreme Court is basically of the opinion that when we say equal protection under the law and the 14th Amendment, that you're not going to discriminate on the basis of race, that means we're not going to take race into account at all. Yeah, totally. So you can see how that makes the Voting Rights Act actually maybe somewhat suspect along with affirmative action.
You know, it'd be great. Because on the one side, people would say, well, the race should not come into play at all when decisions are made on qualifications. It's naive to think that we still don't have levels of discrimination and people need to be protected. So it's a tough balancing act from my vantage point.
Oh, I think that's totally right. And there's a version of it where you can say, there's the glass half full version where you say, is America in a much better place in terms of racial equality than it's been in its history?
But it's still not where we'd like it to be.
Yes, exclamation point. It is. We're a lot better off. Are things fully equal? That's a no. And I think the data reflects that. Yeah. And so that's the bind that we're in.
Now, attorneys general have been under growing scrutiny. They've been accused of bending to the whim of administrations, politically motivated investigations or lawsuits, sweeping aside concerns over potential illegal activity. Is the Justice Department becoming more of a political department instead of one that simply sticks to the law? Are you concerned with what you're seeing there?
Yes, I am very concerned with what I'm seeing there. And again, this is one that goes back to Watergate. We really beefed up the Attorney General and the Department of Justice following Watergate, and then we've just seen a slow decline in terms of keeping politics out of it. It's a hard, similar to the other things I was saying, it's actually kind of hard, right? The current conservative legal version of it is, look, we've got an executive branch, and the head of the executive branch is the president. That's in the Constitution. Everybody knows that. From the current conservatives, they're like, listen, everybody who works in the executive branch works for the president. Shouldn't be confusing or controversial. And so when the president says do something, they should probably do it. If they don't do it, the president should be able to fire them.
That's in the executive branch.
Correct. But that's tough, though, right? Because to a certain extent, you do want, in my opinion, it's going to work better if the Attorney General has some leeway, if the Attorney General can make some of these calls on their own. I don't feel comfortable with the president picking up the phone and telling the Attorney General, I want you to prosecute X. I don't think that's a proper use of that division's power. I mean, the Department of Justice is a really powerful institution.
Yeah, it's a concern, but it's been a problem for years. This isn't new.
This is an example, and people can definitely disagree with me. But this is an example where things that have been a problem for years surface now, and Trump uses this outside voice rather than an inside voice thing. I mean, Trump says, I want to see prosecutions against Obama and the people in the Obama White House who were involved in Russiagate. And a couple of weeks later, there's a grand jury that the Department of Justice has opened.
But he said, what I'm hearing you say is he's saying publicly what typically was always kept behind closed doors, correct. But it's naive to think those things weren't going on.
I think that's right. I think that's
to
right.
a degree.
But I also think that when it happens behind doors, the Attorney General feels more comfortable saying, listen, I don't think we have that case, or I think that's going to be too much. Let me try and talk you out of it. It's a different thing than doing it all publicly, if that makes sense.
Ben, do you think special interest groups, are they a problem on the legal landscape with justices?
So it depends. So let me say two things about that. First, there's a big thing about judicial ethics and about an ethics code for the Supreme Court. And it is, in fact, true that several justices have admitted to taking pretty large gifts from people, large enough gifts where, like even just as a professor at University of Tennessee, if somebody bought me an RV, I would be like, well, that's weird. Sure. I wouldn't feel great about that. And I'm not in a state of area of public trust like on the Supreme Court. So in terms of optics and in terms of like the wisdom of taking those sorts of gifts, I think that's really bad. As to whether they were buying influence, I think that's definitely no. Supreme Court justices, you can't track. So, for example, the people who have been most accused of taking gifts are Alito and Thomas. The two justices who are the easiest to figure out how they're going to vote from the day they got on the court are Alito and Thomas.
Yeah, that's a great word.
If Thomas had gotten a free RV and all of a sudden he was like, I love Democrats, I'm just voting with the left all the time, then I would be worried. But he hasn't changed his stripes one iota. So if you're asking me about whether the special interests have an effect, whether it's like an actual quid pro quo, then I'm a strong no on
Do you think there should be better rules on financial disclosures and potential conflicts and ethics?
Absolutely. I think that's an obvious yes. And they have instituted an ethics code. And the fact that we know about this, now some of these things have come to light and they're doing a better job of talking about the gifts that they get. And that makes me happy. I think that's good.
We're visiting with Ben Barton, professor of law at the University of Tennessee. When we come back, I do want to ask him about the tenure of judges, the fact that it's a lifetime appointment in most cases, and especially with the Supreme Court. Then I also do want to be sure we take a couple minutes and talk about the outlook for the legal profession moving forward. So stay with us. This is More Living with Jim Brogan here on News Talk 98.7 WOKI.
Welcome back to News Talk 98.7's Brogan Financial Studios, where Jim Brogan is coming to you live with important news and advice to help you achieve your dream retirement. Get ready to learn and live. Here's your host, Jim Brogan.
Thanks for tuning in. This is More Living here on News Talk 98.7 WOKI. My next college class for adult education, income planning for retirement. You can go to Pellissippi Retirement Income for more information. Download a syllabus and click to register directly with Pellissippi State. It is 1 night, 2 hours on August 26th at Pellissippi State, Hardin Valley. Again, PellissippiRetirementIncome.com. We're visiting with Ben Barton. We're talking about the legal landscape. And let's talk about, we mentioned term limits. Actually, we talked a little bit off air about that. Of course, the Supreme Court or lifetime appointments. Do you think they should have term limits? I mean, there's an argument for and against. Both of them sound kind of logical.
Yeah. So my first cut take on this is that if it's being done for political reasons, then I'm strongly against it. So, for example, if you were like, we need term limits, and what we need to do is put an age limit so we can get rid of Thomas and Alito, and a theoretical Democratic president would get to replace them, then I don't like that. That's only going to make it more political, and that's bad. That being said, is there an argument that we shouldn't have 80-year-olds, 80-plus-year-olds making these sorts of decisions? I'm very sympathetic.
Well, and that's really come under scrutiny considering, our former president, Joe Biden, in the last couple of years of his presidency.
Oh, for sure. Yeah, no. And you've had some Supreme Court justices who hung on a little bit too long. Ginsburg, in particular, was pretty sick down the stretch. So yes, if they were to put in a rotating age limit or some way of trying to make it so that people stayed on there less, as long as it's not aimed at getting rid of particular political persuasions, I actually think it's a pretty good idea. Yeah.
Now let's pivot and talk about the future landscape of the law field. You authored a book, Fixing Law Schools, and it discusses the Great Recession, how it impacted law school. How's the landscape for law schools changed over the past decade?
Yeah, so in the Great Recession in 2008, hiring was bad for lawyers, but something happened that was strange. It stayed bad for another 7 years. The hiring landscape for lawyers was bad basically from 2008 to 2015, and that meant few. And then because of that, fewer people went to law school. We had a bunch of law schools go out of business.
But the supply and demand of tuition costs didn't seem to affect tuition.
Correct. In part, so not only was the job market worse, but tuition was running in front of inflation, and that tuition had been running in front of inflation since the 80s. So that's a bad situation where you have a worse product that costs more. Yeah. And so
that doesn't work in private industry.
No, it sure doesn't. But 2016 forward, it's ameliorated a lot. We shrunk the number of people who are going to law school. The employment numbers are better. We had the best employment year we've had since probably the 1970s last year. So it's turned for law schools. It's gotten a lot better.
So you think the outlook looks better for even the profession of law?
I do. But we were talking offline a little bit about AI. That's a big, significant looming possibility. There's a glass half full version of it where AI makes it so much more efficient to practice law. It's not like there are a shortage of people who need legal help. You know what I mean? Like, I don't know if you talk to a middle-class person or a working-class person. They could use some advice and they could use some help with a will, or if they're getting evicted, or legal problems at work. So there's a version of it where we're able to make law cheaper and it reaches a lot more people. There's another version of it where AI just replaces lawyers altogether. But as I warn the students, I'm like, well, if that happens, Lord knows where we are.
Well, we have to have the personal touch.
Yeah.
And the personal perspective maybe is a good way to say that.
No, and also the wisdom of it. You'll know from having done investment advising for a long time, you learn a thing or two as you go along, and that's important. A machine can't replace that.
No, so to me, the industry just evolves. Skill sets probably need to evolve with it. That's true in all of our industry with the advent of AI.
Yeah, no, we're redoing our entire first-year curriculum and our treatment of AI at the University of Tennessee, and we're focusing on it. And we're recognizing exactly that point point.
Well, Ben Barton, professor of law from the University of Tennessee. I could just go on and on and on. Thank you so much for taking time out of your
pleasure.
schedule.
Thank you for having me.
That's been great. We talked about really the legal landscape because our rights affect our quality of living so we can live the best years of our lives the way we want to live them. Thank you, Wayne, for engineering the show. Thank you to Jill for helping produce the show. You've been listening to More Living with Jim Brogan, only on News Talk 98.7 WOKI.
The views expressed by Jim Brogan and his guests are not that of Cumulus Media. Any discussion of financial, legal, and tax planning strategies is not intended to be individualized advice and is general in nature. Always consult with your advisor for advice specific to your needs. This program's content does not represent a recommendation of any particular security, strategy, or investment by Jim Brogan or Brogan Financial Incorporated.